Hello, everybody. How are you? My name is Joanne. I'm a law student from Melbourne in Australia, and I want to take you into a case. It's been in the media for a while. There was allegations of racism in an Aussie Rules Football Club. Um, there was a whole pile of people implicated. Uh, that didn't get resolved, and so now we are in the federal court. So I want to have a look at that. We have got the original filings and we've got an update on that. So buckle up. This is a bit of a big one, also a little bit controversial. So we'll try and stick to the facts and you can make up your own mind as what we do. So go grab a chair, sit down, relax, or grab a coffee, and I'll see you in a bit. We have got the case of Cyril Rioli and or others, and the Hawthorn Football Club Limited. We have had a few documents style. We've had a statement of claim, an originating application, some notices, notice to produce a document in a pleading affidavit, and an address for service. This is a public interest case, so whatever is there is available and on the record. Here are all the people that are involved and the legal teams, and it's a human rights case. So we've got the originating application here. It is 84. The originating application, which is the first part of this, looks like this. I'm going to put myself in a little bit of the corner here. So it's the Federal Court Registry in the Victoria. So every state of Australia has a Federal Court Registry. So that means that every state in Australia has a Federal Court, Federal Court section. Originating application under the Australian Human Rights Commission of 1986. Cyril Rioli and others, Hawthorn Football Club. To the respondent, the applicant applies for relief set out in the application. The court will hear this application and make orders for the conduct of the proceedings and the time and place set out below. And so this is just sort of saying this is what's going to happen. So the applicant's claims, as stated in the pleadings, as pleaded in the statement of claim filed together herewith, the respondent, 1, has engaged in unlawful conduct within the meaning of sections 9.1 and 15.1b of the Racial Discrimination Act 1975. It's now referred to as the RD Act in relation to the first applicant, Cyril Rioli, causing him injury, loss, damage, as pleaded in the statement of claim filed together herewith. Has engaged in unlawful conduct, so the same thing, that's a repeat of Shannon R. Sam Rioli, and again the same, causing her injury. Has engaged in unlawful conduct of Jermaine Miller Lewis. We've got Montana Ray Lewis and Carl Peterson and Leon Egan. And that they were not negligent, breached the duties of care owed to them, to each of Mr. Rioli, Mr. Peterson, and Mr. Miller Lewis, causing them injury, loss, damage, as pleaded in the statement of claim. The applicants also claim that the discrimination complained of is unlawful under sections 9 and 15 of the RD Act. They asked the court for orders pursuant to section 46 POA 4A of the Australian Human Rights Commission Act, or otherwise declaring that the respondent has committed the unlawful discrimination alleged in the statement of claim, and directing the respondent not to repeat or continue such unlawful discrimination, to pay the damages, including aggravated damages by way of compensation, because of the respondent's unlawful discrimination. They want apologies. They want the respondents to give apologies to each of the persons. Damages, including aggravated damages in the loss of damage suffered by Mr. Rioli, Mr. Peterson, Mr. Miller-Lewis because of the respondents' breaches of the duties. Exemplary damages in respect of negligence claims made by Mr. Rioli, Mr. Peterson, Mr. Miller-Lewis interest. Such orders as to cost as the court considers appropriate, and such further or other order as the court considers necessary. A copy of the original complaint to the Australian Human Rights Commission constituted by the complaint form from the 2nd of June 2023. Documents 1 to 19 contained in the zip file dated 5th of June. The notice of termination of complaint by the President of the Australian Human Rights Commission on 27th of May 2024. The reasons for the decision. So, yes, it went to the Human Rights Commission first and decided they couldn't take it any further. So it's now come to the court. Containing reasons for decisions, being the applicant's complaint as terminated, and then the forms with that, and the statement of complaint, the applicant's relationships to respondents that they are, in the case of Rioli, Carl Peterson, Jermaine Miller-Lewis, and Leon Egan, former employees of the respondents. In the case of Shannon R. Sam Rioli and Montana Leigh Lewis, partners of Rioli and Jermaine Miller-Lewis, respectively, applicants are over 18. The address, which is the law firm, and then signed by the lawyer for the applicants there. And then notice of filing and hearing. So it's just that's a standard form. So that's 7 pages there. When we get to the complaint is 89 pages long. And so this is the statement of claim. So it's going to take us through each of the sections. So it's very repetitive because it's got to go through each person. So what I'm going to do is we're going to look at it. And I will just say, if it's the same thing, we'll try and get through it as quickly as we can. So the applicant's Mr. Carl Peterson is and I'm sorry, I'm not going to get this right, a Yunga, and Marta Aboriginal man. It's part of the Murchison and Western Desert. Born on the 3rd of July 1987, grew up in Perth and Kununurra. West Australian, was employed by the respondent Hawthorn as a professional football player from 2008 to 2010. From March 2007 for 10 years, was in a de facto relationship with Miss Nikita Richimura, an Indigenous person. Mr. Rioli is an Aboriginal man of the Manupi and Malua clan. His country is on the Tiwi Islands. Palangimpi on Melville Island, and Pajabara on Bathurst Island on his father's side. The Amaji clan, whose country is Tea Tree and Darley River on his mother's side. Born on the 14th of July 1989, he grew up in Palangimpi and Darwin, Northern Territory, until he moved to boarding school in Melbourne at 14 years. Was employed by Hawthorn as a professional football player from 2007 to 2018. Was, and at all times, was in a relationship with or married to Miss Shannon R. Sam Rioli. Miss Shannon R. Sam Rioli is an Aboriginal woman on her father's side of the Garawa and Yangua people, whose country is the Manangura and Burralu, and the Waka Waka people, whose country is Sherborne. On her mother's side, the Meskari people, whose country is Cloncurry, and the Wani people, whose country is Lawn Hill. Was born on the 2nd of January 1991. She grew up in Darwin, the Northern Territory, and was, and at all times, married to Mr. Rioli. Mr. Rioli, Miss R. Sam Rioli, met around 2003 when she was 13 and he was 14. Was in a relationship by 2007 and was married on the 18th of October 2014. Mr. Jermaine Miller-Lewis is a Noongar and Yamati Aboriginal man whose country is Noongar on his mother's side, and Yamati on his father's side. Was born on the 23rd of February 1996, grew up in Stirling and Perth, Western Australia, was employed by Hawthorn as a professional footballer from 2014 to 2016, is and was at all relevant times married to Miss Montana Ray Lewis. Miss Montana Ray Lewis is a non-Indigenous person. Was born on the 23rd of February 1996, grew up in Mora, West Australia, is and was at all relevant times married to Mr. Miller Lewis. Mr. Miller and Lewis and Miss Lewis commenced a relationship in early 2011, commenced living together in 2012. Mr. Leon Egan is a Yorta Bangarang, Riodandri, and Gunjamara man. Born in Wagga Wagga in the Wadaji country on the 29th of March 1969. Grew up in Wagga Wagga and moved to Melbourne when he was 13 years of age. Was engaged and employed by Hawthorn as Indigenous Mentor Advisor from 2012 to 2015. The respondents and its employers and agents. Hawthorn is and was at all relevant times a not-for-profit Australian public company limited by guarantee and capable of being sued in its own name. From the 16th of December 2013, Hawthorn operated pursuant to the Constitution of the Hawthorn Football Club Limited. The Constitution was amended on the 11th of December 2018. At all times, Hawthorn relevantly fielded a team in the men's national competition conducted by the Australian Football League. I'm just going to increase this, make this, how do I make this, yeah. You might be able to see it better. Competition conducted by the Australian Football League pursuant to licence granted by the AFL Commission. At all relevant times, Hawthorn was required to comply with rules, regulations, bylaws, policies and procedures, howsoever else described by the AFL and or the AFL Commission. Mr. Alistair Clarkson was employed by Hawthorn as head coach between 2005 and 2021, acting within the scope of his employment in doing and failing to do so the things pleaded in his statement of claim. Mr. Chris Fagan was employed by Hawthorn as the head of coaching and development between 2008 and 2013, the general manager of football between 2013 and 2016, acting within the scope of his employment in doing or failing to do the things pleaded in this statement. Mr. Jason Burt was employed by Hawthorn as Head of Player Services and Football Administration Manager between 2006 and 2016. The General Operations Football Manager from 2016 to 2018, General Manager People, Culture and Integrity between 2017 and 2019, acting within the scope of his employment in doing or failing to do the things pleaded in this statement of claim. Mr. Cameron Matthews was employed by Hawthorn as a Player Development Manager between 2014 and 2021, Football Operations Manager between 2021 and 2022, acting within the scope of his employment in doing or failing to do so the things pleaded in this statement. Mr. Mark Evans was employed by the Hawthorn as the General Manager, Football Operations between 2005 and 2013, and then they've put in the Part B, which is the same as the others. Mr. Jeffrey Kennett was the President of Hawthorn between 2005 and 2011, and between 2017 and 2022, acting within the scope of his responsibilities and or was acting as an agent of Hawthorn in doing or failing to do the things pleaded in this statement. Mr. Graham Wright was employed by Hawthorn Football Department between 2007 and 2018 in recruiting and list management between 2018 and 2021 and head of football. Again, we've got this. So now we've got how the history of the case, how it went to the Human Rights Commission. So on the 2nd of June 2023, the applicants lodged the complaint with the Australian Human Rights Commission. On the 27th of May 2024, the Commissioner terminated the complaint pursuant to the power in the Human Rights Commission Act. Hawthorn's Conduct Policy Framework. Further to 11, at all times, Hawthorn was required to comply with AFL rules. The particulars. The rules are in writing and publicly available. At all times, the rules A require that no person subject to rules and regulations shall act towards or speak to another person in a matter or engage in conduct which threatens, disparages, vilifies, insults another person on any bias, including but not limited to a person's race, religion, colour, descent, or national or ethnic origin, disability, sexual orientation, or gender identity, and in brackets the Peak Rule. The rule introduced as Rule 30 in 1995 in the aftermath of the Indigenous Essendon player Michael Long experiencing racial abuse during the Dawn Anzac Day match. The rule was amended in 1997 to provide for conciliation, education and confidentiality, to introduce new penalties and extend beyond players to employees of AFL clubs with on-field access. The rule was amended in 2009 to broaden the grounds on which a complaint could be made to include the vilification on the basis of ability, special ability, and sexual orientation, preference, or identity. However, at the time, the rule applied to on-field incidences. In 2013, the rule was renumbered as Rule 35 and extended to off-field incidences. The rule was amended in 2021. From on or about March 2021, on the recommendation of Mr. Long, the rule became known as the Peak Rule. The rule is now Rule 35, in particular 35.1. Had the effect that unless Hawthorn took all responsible steps to prevent persons employed, engaged, or otherwise associated with from engaging in conduct which contravened the Peak Rule, Hawthorn would be deemed to be vicariously liable for the conduct of such person contravening the Peak Rule. AFL Rule 35.15 enabled Hawthorn to lodge by a club official a complaint in writing with complaints officer of the AFL alleging a contravention of the Peak Rule. AFL Rule 35.2 provided a framework for dealing with complaints mentioned in the last subparagraph, such that had Hawthorn lodged such a complaint, the process by which it would have been dealt with was, in the first instance, by conciliation, following which, if the complaint was resolved, the subject of the complaint would attend an education program approved by the AFL, unless the conciliator reasonably considered the subject of the complaint had not contravened the Peak Rule. 2. If the complaint was not resolved at conciliation, referral to the disciplinary tribunal. AFL Rule 35.3 to 35.12, further to point 11. A, from 2006 to 2009, Hawthorn was required to comply with the anti-discrimination and harassment policy. So it's going to be referred to the ADH policy, contained in 7.2 of the Australian Football League Member Protection Policy. The ADH policy, applicable from 2006 until 2009, was in writing, publicly available and undated. B, from January 2009 to 2013, Hawthorn was required to comply with the anti-discrimination and harassment policy, together with the ADH policy, contained at 5.2 of the Australian Football League and affiliated state body member protection policy. The ADH policy, applicable from January 2009 until February 2013, was in writing, publicly available, dated 2009 and described as version 2. In 2013, Hawthorn was required to comply with the National Vilification and Discrimination Policy of the AFL leagues and affiliated bodies. The discrimination policy is in writing, publicly available and dated February 2013. Affiliated leagues and bodies are defined in Section 3 of the discrimination policy. From 2006 to 2009, the ADH policy, A, prohibited discrimination and requesting, assisting, instructing, inducing, or encouraging discrimination on the basis of relevantly marital status, pregnancy, race, sex, or gender, together with the prohibition pleaded below at 25A and 26A, discrimination prohibition. I can't say that word. Prohibition. Section 7.2 read with the dictionary definition of discrimination. Prohibited, I can say that word, prohibited harassment, which was defined as any type of behaviour that the other person does not want and does not return, that is offensive, abusive, belittling, threatening, and included abuse such as bullying, humiliation, verbal abuse, and insults, together with the prohibition pleaded below and the harassment one, read with the dictionary definition of abuse and harassment. From February 2009 until February 2013, the ADH policy prohibited discrimination and requesting, assisting, instructing, inducing, encouraging discrimination on the basis of relevantly marital status, pregnancy, race, sex, gender, social origin, and association with a person having one of these characteristics together. The prohibition pleaded above. Prohibited harassment, again, we've got the same thing. So you have a look. It prohibited harassment, requesting, all right. And at all relevant times from February 2013, discrimination policy prohibited conduct by league participants and club officials that may reasonably be considered to incite hatred towards, contempt for, ridicule of, or discrimination against a person or groups of persons on the ground of their race, religion, gender, colour, sexual preference, orientation or identity, or special ability or disability. Prohibited conduct by league participants and club officials that may reasonably be considered to be offensive, abusive, belittling, threatening, or which was otherwise unwelcome, and a reasonable person would recognise it as being unwelcome and likely to cause the recipient to feel offended, humiliated, intimidated, together with the prohibition pleaded above. C, required the AFL to ensure Hawthorn had the club complaints officer, section 5. D, enabled employees and agents of Hawthorn to lodge a complaint with the club complaints officer in the event of an alleged breach of the discrimination prohibition or harassment prohibition by, relevantly, another member of the club. Provided a framework for dealing with complaints mentioned in the last sub-paragraph, that such had an employee or agent of Hawthorn lodge such a complaint. The process by which such an intra-club complaint would have been dealt with was one, in the first instance, by informal resolution, following which, if the complaint was not resolved or considered to be incapable of informal resolution, lodging the complaint with the AFL's complaints officer. 2, for complaints lodged with the AFL complaints officer by a process of conciliation and potential investigation. For complaints not resolved by conciliation, by disciplinary tribunal hearing. Further to 11, from August 2017, Hawthorn was required to comply with the Australian Football League's respect and responsibility, the R&R policy. The R&R policy is publicly available in writing and dated August 2027. At all times, from 2017, the R&R policy, on page 10, recognised that AFL clubs, including Hawthorn, may be perceived to have or actually have been found to have a conflict of interest in dealing with accusations against one of their club members or officials. Provided a mechanism, relevantly clubs, including Hawthorn, to consider how issues of alleged or proven unacceptable conduct in personal life of AFL personnel would impact their recognition as a leader of the game and in the community, enabled Hawthorn to make or disclose a complaint about a breach of the R&R policy to the AFL. Further to 11, Hawthorn was required to comply with the AFL vilification framework. The vilification framework is in writing, publicly available. Particulars of the commencement date of the vilification framework will be provided after discovery. So this is the vilification framework recognised. On page 3, clear links between ethnic and race-based discrimination and issues such as depression, psychological distress, stress and anxiety. On page 3, probable links between ethnic and race-based discrimination and poor general health, quality of life, alcohol and substance misuse, smoking and peer violence. On page 8, required Hawthorn to observe all facets of the vilification framework and endorse future activities, including including establishing and promoting connections with support services and developing social responsibility components of the framework. On page 10, provide the Hawthorn as a key stakeholder within the AFL industry aim to raise awareness of the importance of the AFL industry being an inclusive environment for all people, irrespective of their particular backgrounds and characteristics, raise awareness across the AFL industry of the impact that vilification can and does have on individuals, clubs, the industry, and the wider community. On page 11, recorded that Hawthorn, as a key stakeholder within the AFL industry, undertook to educate AFL industry on the impact of that vilification can have on individual clubs, the industry, and the wider community, build the capacity of the AFL industry to recognise, address, and provide support to persons who are affected by vilification of any form. On page 11, required that Hawthorn work collaboratively with the development and delivery of education programs to ensure consistency of messaging relating to vilification. So now we're getting into all the facets of the employment relationship. So at all times, Hawthorn employed its players and any Indigenous mentors advisors, including persons in equivalent roles, by contracts. At all relevant times, there existed an AFL's Players Code of Conduct, the purposes which included to establish a set of performance and behaviour for each AFL footballers and to clarify the duties and obligations set out in each club's contract with players. The code is in writing, publicly available, and amended from time to time. Hawthorn was consulted on the code and at all relevant times knew of its content. Clause 1.1 of the code states that each AFL club was consulted in relation to formulation of the code. At all times, the direction by Hawthorn to players it employed that they were to comply with the code would have been or was lawful and a reasonable direction. At all times, the code, A, recognised that the player was entitled to have his privacy, including that of his families and friends, respected, and that the code was not intended to apply activities engaged by a player of a private nature, which may include activities with family, friends, and or other players. That's 1.2. Provided that players must not willfully engage or participate in any activity which prevented players from playing AFL football to the best of their ability. Clause 3.1, previously 2.2. Provided that players must not vilify other players on the basis of their race, religion, sex, colour, sex, or sexual orientation, or other related characteristics. That's the non-vilification provision, 3.4, previously in skip. Provided that breaches of the non-vilification provision, which should be dealt with in accordance with rules 3.4, previously in the schedule, included provisions with the imposition of disciplinary measures by the AFL clubs on AFL players, clause 8, previously clause 5. At all relevant times, Hawthorn's position as an employer of the applicants enabled it to give applicants, including through the individuals defined in paragraphs 12 and 18, lawful and reasonable directions with which the applicants would be obliged to comply, and guidance suggestions with which it was reasonably to be expected that the applicants would comply. Relatedly, at all relevant times, Hawthorn's position as an employer to those in leadership positions, such as those held by individuals identified at 12 to 16 and 18 above, and vis-a-vis its president, allowed it to, C, implement in respect of those individuals and required that those individuals comply with anti-racism training activities and protections, 2, other training activities and protections directed to player and other employee well-being. D, give such of those people as were its employees lawful and reasonable directions with which they would have been obliged to comply. Give such people guidance or suggestions with which it was reasonably to be expected that they would comply. So now we get into specific conduct. So this was conduct in regards to Mr. Peterson. He was selected by Hawthorn with pick 61 in the 2009 National Rookie Draft. He was employed by Hawthorn commencing December 2008. Had sufficient skill and abilities as a football player of that age to have a long and successful career. When he commenced at Hawthorn, he was 21, had been drafted by Richmond in 2006, had suffered osteoarthritis pubis and was placed on the long-term injury list while at Richmond, had suffered injury to his arm requiring stitches, delisted by Richmond in December 2007, failed a voluntary drug test organised by Hawthorn in November 2008. Hawthorn knew of each of the matters in the above paragraph. Once at Hawthorn, Mr. Burt said to Mr. Peterson, words to the effect, Hawthorn did not believe Mr. Peterson should get an agent because of the percentage they charged. Mr. Burt would do it, i.e. the job of the agent, for free. Mr. Burt said words to the effect within a few months of Mr. Peterson joining Hawthorn. From around January to June 2009, Mr. Peterson resided part of the time at a host family house and part of the time at Miss Rotimer's house in Heidelberg, where she lived with her toddler son from a previous relationship. 2009, approximately February or March, Mr. Peterson and Miss Rotimer found out they were pregnant, but Miss Rotimer later suffered a miscarriage. From around March 2009, Mr. Burt would from time to time question Mr. Peterson about his life outside football, including asking Mr. Peterson about drugs and alcohol, Mr. Peterson's perceived lack of financial accountability, and whether Mr. Peterson was seeing Mrs. Rotimer. Burt would speak to Mr. Peterson in person on a weekly basis at the Waverley Training Centre. In about March or April 2009, Mr. Burt said to Mr. Peterson words to the effect that Hawthorn was opposed to him being in a relationship with Miss Rotimer. Mr. Burt said words to the effect at the Waverley training facilities. On or about the 3rd of July 2009, Hawthorn hosted a birthday dinner for Mr. Peterson at Hawthorn employee Mr. David Flodhouse, but did not invite his Indigenous friends or family. Mr. Clarkson and another Hawthorn employee, Damien Hardwick, were present. On around July or August 2009, Mr. Peterson and Mr. Rotimer found out they were pregnant again. Mr. Peterson told Mr. Burt about the pregnancy around 11 or 12 weeks of gestation. A few days later, immediately following a training session, Mr. Burt told Mr. Peterson that the coaches wanted to meet him, but Mr. Burt did not otherwise inform Mr. Peterson of the purposes of the meeting. Mr. Peterson then attended the meeting in a small office at the Hawthorn facilities. Mr. Clarkson, Mr. Fagan, and Mr. Burt were present in the room before Mr. Peterson arrived. At the meeting, there were initially some friendly and positive discussion about how impressed the coaches were with Mr. Peterson's development and skills as a player. Mr. Burt then informed Mr. Peterson that he had shared Mr. Peterson's news with Mr. Clarkson and Mr. Fagan. Mr. Burt said words to the effect of, Carl, being a father is a huge responsibility and we don't think you're ready to be a father. Mr. Clarkson said words to the effect, Carl, you need to break up with Nikita and focus on your football. Mr. Clarkson said words to the effect of, unless you break up with her and tell her to terminate the pregnancy, your football career will be in jeopardy. Mr. Fagan nodded his head during the meeting. Mr. Peterson gave them an answer. Mr. Peterson should give them an answer in the next hour or so. Mr. Peterson then left the office and went to an area where Hawthorn usually held press conferences. He was highly distressed and anxious about what he'd been told. Did not consider, in light of what he'd been told and in the circumstances to which he'd been told these things, that he realistically had any option but to comply. He called Miss Rotimer and said to her words to the effect that he could not be with her anymore and that it was not a good idea that she have the baby. Mr. Peterson then told Mr. Clarkson and Mr. Burt words to the effect that he told Miss Rotimer that it was not a good idea to have the baby and it was not a good idea for them to see each other. The discussion occurred approximately half an hour or so more after the initial meeting. Mr. Fagan was not present for the discussion. Mr. Clarkson and Mr. Burt then said to Mr. Peterson Words to the effect that Mr. Peterson would be staying at Mr. Burt's house for a few days. Mr. Burt then drove Mr. Peterson to Mr. Burt's house. On the way, Mr. Burt purchased a SIM card, said to Mr. Peterson words to the effect that it would be best if Mr. Peterson was not able to communicate with his family anymore, so he could be 100% committed to his training. Mr. Peterson said he needed to comply with Mr. Burt's instructions, then stayed at Mr. Burt's house for a number of nights in an upstairs room. During the time he stayed at Mr. Burt's house, Mr. Peterson felt that he was being locked away from the outside world, and the only interaction with others that was permitted by Hawthorn was with his teammates at training. About a week later, Mr. Burt and Mr. Flood met with Miss Rottimer and her mother at Birdie Num's Cafe in Carlton. Mr. Burt said to Miss Rottimer words to the effect that Hawthorn had encouraged Mr. Peterson not to be a father. Miss Rottimer did not terminate the pregnancy. In October 2009, Mr. Peterson and Miss Rottimer resumed their relationship. In or around January 2010, Mr. Burt said to Mr. Peterson, Miss Rottimer words to the effect that they should move out of Heidelberg because it was too rough and into a classier suburb. The conversation was with Mr. Burt in person. Because of being told on about January 2010, Mr. Peterson and Miss Rottimer moved house to Templestowe. About that time, Mr. Peterson and Miss Rottimer moved to Templestowe. She was 37 weeks pregnant. She was planning to be due at 38 due to gestational diabetes. On February the 8th, 2010, she gave birth to their son. After Mr. Peterson's son was born, Mr. Clarkson visited Mr. Peterson's home in Templestowe. Said words to the following: "This house is nice. You have kids' artwork up. It's nice and clean. You should invite teammates over for dinner and things. You know, for all they know, you're living in a shack in the desert somewhere." Mr. Clarkson said the words in the presence of Miss Rottimer. In or about November 2010, Mr. Peterson was delisted by Hawthorn and his employment at Hawthorn ceased. Mr. Peterson's delisting was communicated with him in a meeting with Mr. Clarkson, Mr. Fagan, Mr. Flood, and Mr. Burt. In or around July 2029, Mr. Peterson took his young family members, his stepson, his two sons, and Miss Rottimer's younger brother to Hawthorn training facilities. While there, they incidentally missed Mr. Clarkson. Mr. Clarkson pinned Mr. Peterson's son, LP, up against the wall with his forearm on LP's chest and hand gripping LP's shirt. Okay, so now we get into Cyril Rioli and Shannon R. Sam Rioli. So Mr. Rioli was drafted in 2007 to Hawthorn at 18. He commenced employment in 2007. Mr. Sam Rioli and Mr. Rioli were in a relationship when he was drafted to Hawthorn and while he was at Hawthorn. Throughout Mr. Rioli's time at Hawthorn, Mr. Clarkson called Mr. Rioli Humphrey B. Bear, thereby associated Mr. Rioli with a black bear and chose publicly to refer him in that way. During Mr. Rioli's employment at Hawthorn employees regularly said things to Mr. Rioli that were culturally ignorant. Instances of the kind occurred on various dates in various places. Example include Mr. Clarkson saying to Mr. Rioli when he was sitting with other Indigenous players words to the effect, "Oh, all the brother boys are together. Why don't you come and sit with everyone else? Why are you always sitting together?" Other examples of culturally ignorant statements alleged at 77E and 94 below. Mr. Sam Rioli learned of the matters pleaded in the previous two paragraphs shortly after they occurred. In the off-season, in mid-September 2011, Mr. Rioli was in Darwin enjoying his time with family. Mr. Clarkson travelled to Darwin to visit Mr. Rioli, attended at Mr. Rioli's uncle's house and suggested that Mr. Rioli and Mr. Clarkson have a meeting at the hotel at which Mr. Clarkson was staying. Then he drove Mr. Rioli to Mr. Clarkson's hotel. In the lobby of the hotel, questioned Mr. Rioli about how the off-season was going. So where's the effect? Be careful not to have babies and understand that your career was has just taken off and a child will disrupt your career or potentially end it. Mr. Rioli told Miss Sam Rioli the facts pleaded in the preceding paragraphs in the month after that occurred. Mr. Jed Anderson is a Rarotonga man who was born in Katherine, Northern Territory on the 2nd of February 1994 and moved to Darwin when he was 12 years old. He was drafted to Hawthorn in around October 2012. When he arrived in Melbourne in November 2012, having been drafted by Hawthorn, stayed with Mr. Rioli and Miss Sam Rioli. Mr. Anderson's partner, Miss Nikki Anderson, is non-Indigenous. Came down to Melbourne from Darwin to sit with Mr. Anderson in late November 2012 and also stayed at Mr. Rioli, Miss Sam Rioli's house and was at the time 5 to 6 months pregnant. On the same day, Miss Anderson arrived in Melbourne and went to Mr. Rioli and Miss Sam Rioli's house. Mr. Clark and Mr. Burt, I think it's supposed to be Clarkson, Mr. Burt attended the home unannounced with another Hawthorn employee. Mr. Rioli and Miss Sam Rioli were present for this visit. In the course of that visit, Mr. Clarkson said to Jason, Mr. Rioli's cousin, words to the effect that he was to go upstairs. Said to Miss Anderson in the presence of Mr. Anderson, Mr. Rioli and Miss Sam, words to the effect of Nikki, it's in the best interest of Jen and Cyril that you do not stay here. Mr. Clarkson said to Mr. Henderson and Miss Anderson words to the effect that they should pack Miss Anderson's bag and that Miss Anderson should meet them outside as she had to return to Darwin immediately. In March to April 2013, Miss Sam Rioli emailed Mr. Burt suggesting that Hawthorn should undertake cultural awareness and safety training. The email was sent from Miss Sam Rioli's work account at VACCHO. About a week later, Miss Sam Rioli asked Mr. Burt about her email. Mr. Burt says, I haven't had a chance to check my emails. Mr. Burt said words to this effect in person after a Hawthorn game. About 2 or 3 weeks after Miss Sam Rioli's email, Miss Sam Rioli asked Mr. Burt about her email. Mr. Burt said words to the effect, yes, I have seen the email. I'll get back to you. Mr. Burt said the words to this effect in person outside the rooms at the MCG. Mr. Rioli was present for this conversation. Mr. Burt never got back to Miss Sam Rioli orally or in writing. At the end of the 2013 season, at the end of the season player trip, an Indigenous player, Mr. Bradley Hill, was asked by non-Indigenous player, Mr. Grant Bertram, whether Mr. Hill's partner was using a boom. Mr. Hill told Mr. Rioli of this comment on the first pre-season training late around November 2013. Mr. Hill told Miss Sam Rioli of this comment within a week of telling Mr. Rioli about it. D. Hawthorn did not take any action in response to this incident. From no later than 2015, Mr. Rioli felt culturally unsafe at Hawthorn. Miss Sam Rioli felt culturally unsafe at Hawthorn. Miss Sam Rioli did not participate in so-called WAGs, wives and girlfriends events, as a result of feeling culturally unsafe. Mr. Rioli was questioned about Miss Sam Rioli's non-participation in so-called WAG events. Miss Sam Rioli would, at Hawthorn events, stand at a distance, at the back or in a corner, and to allow time for her to prepare if somebody was to approach her. Mr. Rioli would not leave Miss Sam Rioli alone for long at Hawthorn events, including after games. On or about the 3rd of April 2016, Miss Sam Rioli took Mr. Rioli's nephew to the players' change rooms to see Mr. Rioli. Mr. Rioli's nephew, who is Indigenous, was 13 or 14 at the time. A Hawthorn employee asked to see their wristbands, pointed at the young boy and said, now you behave yourself when you get in there. The next weekend, Miss Sam Rioli recounted the incident, pleaded at 90 to Mr. Clarkson. Miss Sam Rioli said words to the effect of asking Mr. Clarkson if he would be open to cultural awareness and safety training for himself and Hawthorn. Mr. Clarkson nodded a few times and kept walking and did not otherwise respond. In 2017, Mr. Rioli's father had a heart attack, and Mr. Rioli and other family members, including Miss Sam Rioli, gathered in Alice Springs. Mr. Clarkson, unannounced, attended the Alice Springs Hospital where Mr. Rioli's father was located. During his visit to Alice Springs, Mr. Clarkson said to Mr. Rioli words to the effect of, "Why do these Aborigines have darker skin than you?" Mr. Clarkson said the words to this effect in Todd Mall in the Alice Springs CBD. Mr. Rioli told Miss R. Sam Rioli of the facts pleaded in the preceding paragraph on the same day they occurred. On or about the 2nd of June 2018, Miss R. Sam Rioli attended Hawthorn's game in the Indigenous round at Launceston Oval in Tasmania. In the Launceston airport after a game, Mr. Kennett said to Miss R. Sam Rioli concerning her ripped jeans words to the effect, "1, can't you afford to buy thread? 2, while grabbing his pocket, I'll give you change so you can afford to buy thread to stitch those jeans up." Mr. Kennett said those words to this effect in the presence of Miss R. Sam Rioli's brother Peter and Miss Jennifer Lulu Coombs and her 2 sons. Mr. Rioli learnt of these facts pleaded above shortly after they occurred. Because of this incident and against the background of other matters alleged at 71 to 85 above, on the 6th of June 2018, Mr. Rioli did not attend training. He requested 2 weeks' leave so that he and Miss R. Sam Rioli could return to Darwin to a culturally safe space. They gave serious consideration whether Mr. Rioli should stop playing for Hawthorn in light of this final score. On or about the 10th of June 2018, Mr. Wright attended Miss R. Sam Rioli's mother's house in Darwin. During a conversation with Miss R. Sam Rioli there, Mr. Wright said to Miss R. Sam Rioli words to the effect that her reaction to the incident may be the result of being triggered from a past event or her childhood. On or about the 23rd of June 2018, Mr. Clarkson telephoned to Miss R. Sam Rioli's mother and spoke to her younger sister, Jordan. Said to Jordan was of the effect of asking her to fly down to Melbourne to talk to Mr. Rioli. Miss R. Sam Rioli to try and convince Mr. Rioli not to resign from employment from Hawthorn. On or about the 28th of June 2018, Mr. Rioli received a text message from an employee of the Hawthorn media team, Claire Pettifer, which was to the effect inter alia that Mr. Rioli and Miss R. Sam Rioli had to sit down with Mr. Kennett, or Hawthorn would leak the story to control the narrative. Copies of the text message are no longer available to Mr. Rioli. On or about the 29th of June 2018, Mr. Rioli and Miss R. Sam Rioli met with Mr. Kennett concerning the incident described in 96 above. In that meeting, Mr. Kennett said inter alia words to the effect, "I can't help how you feel." In order to protect himself, Miss R. Sam and his family from what had become a culturally unsafe environment at Hawthorn, Mr. Rioli decided to end his employment at Hawthorn in June 2018. I think that was supposed to be Mr. Rioli. Oh no, in order to protect himself, yeah, Miss R. Sam Rioli and his family. Okay. From what had become a culturally unsafe employment environment at Hawthorn, he decided to end his employment with Hawthorn. After his retirement around the 19th of July 2019, Hawthorn used Mr. Rioli's image in its reconciliation action plan without his consent or otherwise consulting him. The reconciliation action plan was published on the 19th of July 2019 and is publicly available. Mr. Rioli's image appears on pages 7, 8 and 12. In or about April 2022, Mr. Rioli texts Mr. Kennett requesting that the images of him be removed from the reconciliation action plan. Copies of the text messages are no longer available. Okay, we're up to the next couple. Hawthorn's conduct in respect to Mr. Jermaine Miller Lewis and Miss Montana Ray Lewis. So Mr. Lewis was drafted to Hawthorn in the 2014 National Rookie Draft, was employed by Hawthorn in 2014. He was in a relationship. Miss Lewis was in a relationship with Mr. Miller Lewis when he was drafted to Hawthorn and throughout his employment. When he was drafted, they were both 18, and she was 7 months pregnant with a due date of the 12th of January 2015. In or about December 2014, at the Hawthorn facilities at Waverley Park, Mr. Lewis Miller had a conversation with Mr. Matthews, in which the conversation Mr. Miller Lewis told Mr. Matthews that Mr. Lewis was pregnant. Mr. Matthews said words to the effect that he was shocked by the pregnancy and that Mr. Miller-Lewis needed to let Mr. Burt know immediately. On about the same day, Mr. Miller-Lewis had a conversation with Mr. Burt at the Hawthorn facilities with Mr. Matthews present, in which the conversation, Mr. Miller told Mr. Burt how excited he was for the arrival of his first child and stated he was ready to be a father. Mr. Burt said, "Are you ready to be a father?" or words to that effect. That it would be challenging for Mr. Miller-Lewis to be a father and a footballer so early in his career, words to the effect that he was shocked by the pregnancy. In December 2014, Mr. Miller-Lewis relocated from Perth to Melbourne and lived with Mr. Egan and Mr. Egan's partner. Miss Lewis remained in Perth. Miss Lewis intended that Miss Lewis would move to Melbourne to live with Mr. Miller-Lewis. Mr. Miller-Lewis had not previously lived away from his family and had no family or cultural support in Melbourne. Mr. Miller-Lewis understood and believed that he would need to comply with directions and requests made of him by Hawthorn, including its employees, or he would put his position with Hawthorn at risk. For example, Mr. Miller-Lewis had to seek permission to visit Miss Lewis. On 20th of January 2015, Hawthorn permitted Mr. Miller-Lewis to travel back to Perth to be with Miss Lewis for the birth of their child. On the 22nd of January 2015, Miss Lewis gave birth to the couple's daughter, Ariana. On or about the 24th or 25th of January 2015, Mr. Matthews told Mr. Miller-Lewis and said words to the effect that Mr. Miller-Lewis needed to come back to Melbourne to resume pre-season training immediately. Although Mr. Miller-Lewis wished to stay with Miss Lewis and their new baby because of the call from Mr. Matthews, Mr. Miller-Lewis returned to Melbourne shortly thereafter. On or about the 2nd of February 2015, Miss Lewis became ill with mastitis, had an allergic reaction to the antibiotics prescribed to treat the mastitis. On or about the 5th of February 2015, Miss Lewis' mastitis became so severe that her right breast burst and most of the breast tissue was hanging out of the wound. She was admitted to Swan District Hospital, now called St. John of God Hospital, Midland. Miss Lewis received major surgery, requiring her to remain in hospital until around the 9th of February 2015. For 6 to 8 weeks after surgery, Silver Chain Home Health attended Miss Lewis at her home every day to pack the open wound on her right breast. Mr. Miller-Lewis said to Mr. Matthews words to the effect that he was very stressed about Miss Lewis' health. Neither Mr. Matthews nor any Hawthorn employee asked if Mr. Miller-Lewis would like to return to Perth to be with Miss Lewis and their baby as Miss Lewis recovered, or offered Mr. Miller-Lewis any other support in connection with Miss Lewis' health issues. On or about late January or early February 2015, Mr. Miller-Lewis was selected to play the AFL Indigenous All-Stars game to be held on the 13th of February 2015 in Perth. On or about the 6th of February 2015, Mr. Miller-Lewis arrived in Perth and in the week prior to the game and participated in a week of leadership, industry and cultural activities. On or about the 6th of February 2015, Mr. Lewis and Mr. Matthews had a number of conversations in which Mr. Miller-Lewis asked for permission to stay with Miss Lewis in Perth rather than at the team accommodation. Mr. Matthews said words to the effect that Mr. Miller-Lewis was not allowed to stay with Miss Lewis and that he had to stay with the team. Mr. Miller-Lewis repeated his requests a number of times and Mr. Matthews rejected these repeated requests. In defiance of the position expressed by Mr. Matthews, Mr. Miller-Lewis did stay with Miss Lewis and their baby on the trip to Perth for the Indigenous All-Star Games, woke at around 4 a.m. each day so that Miss Lewis could drop Mr. Miller back at the team accommodation. During that time, Mr. Miller-Lewis was in Perth. Mr. Matthews said to Mr. Miller-Lewis that Mr. Matthews had learnt that Mr. Miller-Lewis had stayed with Miss Lewis, said words to the effect that Hawthorn was unhappy with Mr. Miller-Lewis and that Miss Lewis had not followed what they had been told by Hawthorn. After Mr. Miller-Lewis's return to Melbourne from the Indigenous All-Stars game, but during the first half of 2015, Mr. Miller-Lewis and Miss Lewis made requests of Mr. Matthews that Miss Lewis and the baby be permitted to visit Melbourne. The requests were made 2 to 5 times per month. Mr. Matthews refused each request. Mr. Matthews, on one occasion of refusing such a request, said to Miss Lewis to the effect that for Miss Lewis and their baby to visit would be a distraction to Mr. Miller Lewis's career. Mr. Matthews, on one occasion of refusing such a request, questioned how Miss Lewis thought she could afford to travel with her baby, or words to that effect. In or around March of 2015, both Miss Lewis and Mr. Miller Lewis's mother, including Miss Teresa Miller, became increasingly concerned about his mental health, including because of his isolation from family and the absence of any cultural support. Around 2015, Miss Miller approached Mr. Matthews with a proposal that she and Miss Lewis and the baby move to Melbourne to provide Mr. Miller Lewis with the support of his immediate family. Hawthorn refused. The proposal was made by phone call and text messages. Copies of the text messages are no longer available to Miss Miller. In relation to the proposal identified in 131 above, in or about April or March or April 2015, Mr. Matthews said to Miss Lewis and Mr. Miller Lewis words to the effect of asking how they would be able to afford to live in Melbourne. In or about March or April 2015, Mr. Matthews said to Miss Lewis on the phone that the family could not afford to relocate to Melbourne. As a result of the interactions with Mr. Matthews alleged at 132 above, neither Miss Lewis nor Miss Miller moved to Melbourne at that time, and Mr. Miller Lewis remained without any family or cultural support in Melbourne. In 2015, Mr. Miller Lewis spoke to Miss Miller about having a player manager mentor. Miss Miller Lewis suggested his uncle Chris Lewis, a former AFL player, a former star AFL player. Mr. Miller Lewis then met with Mr. Lewis and they spoke about what supports could be in place for Mr. Miller Lewis. In or about 2015, Mr. Miller Lewis made it known to Hawthorn that he wanted to engage a player agent, in particular Mr. Lewis. Mr. Burt said words to the effect that Mr. Miller Lewis was just a rookie draft with a 1-year contract, and it was not necessary at that time to obtain a player mentor. Miss Miller was present for this conversation. As a result of Hawthorn's reaction to his proposal to engage a player agent, Mr. Miller Lewis did not pursue this further in 2015. In early 2015, ahead of her and Mr. Miller Lewis's birthday on the 23rd of February 2015, Miss Lewis requested Mr. Matthews that she be allowed to visit Mr. Lewis in Melbourne. In the weeks following, Miss Lewis had additional conversations with Mr. Matthews in which Mr. Matthews said words to the effect that he would only consent to Miss Lewis visiting a short time, no more than 2 weeks, because he did not want her and the baby to distract Mr. Miller Lewis. These communications were by text and by phone call. Copies of the text messages are no longer available to Miss Lewis. On or about the 15th of April 2015, Mr. Lewis booked flights for Miss Miller, Miss Lewis and the baby to arrive in Melbourne on Monday, the 18th of April 2015. On April or May 2015, Miss Lewis and the baby travelled to Melbourne and stayed with Mr. Miller Lewis at the Egan's house. At the end of the visit, Mr. Miller Lewis and Miss Lewis decided that Miss Lewis and the baby should stay in Melbourne. Mr. Miller Lewis texted Mr. Matthews with words to the effect that Miss Lewis did not get on her flight and that they were too upset and did not want to be separated. Mr. Matthews texted Mr. Miller Lewis words to the effect to get Montana on that flight. Mr. Matthews and Mr. Burt telephoned Mr. Miller Lewis and each said words to the effect that Miss Lewis needed to get on the flight back to Perth immediately and that she had no other option. A Hawthorn employee rescheduled Miss Lewis's flight the next day or a few days later against the wishes of Mr. Miller Lewis and Miss Lewis. But as a result of the exchange with Mr. Matthews and Mr. Burt, Miss Miller and Miss Lewis returned to Perth. Copies of the text messages are no longer available to Mr. Miller Lewis or Miss Lewis. 2 days after Miss Lewis returned to Perth, Mr. Matthews informed Mr. Miller Lewis they had to attend the meeting. The meeting occurred at which Mr. Burt and Mr. Matthews were present. No Indigenous liaison officer or support person for Mr. Miller Lewis was present. Mr. Burt said to Mr. Miller Lewis, words to the effect, Jermaine, you failed that test. Mr. Miller-Lewis needed to be more cutthroat when it comes to his family. Mr. Miller-Lewis would need to choose between his family and his career at the club. Mr. Burt said words pleaded above aggressively, pointing his finger at Mr. Miller-Lewis and yelling. The meeting occurred in Mr. Burt's office after a training session. After this meeting, Mr. Miller-Lewis's mental health declined. Mr. Miller-Lewis spoke with Hawthorn's club psychologist, who in 2015 was Anthony Plazia, and in 2016 was another person, about feeling depressed, isolated, separated, wanting and needing his family with him, the cultural necessity of staying connected to family and not feeling like himself because of being separated from his cultural kinship. Miss Miller and Miss Lewis raised Mr. Miller-Lewis's mental health with Mr. Matthews on multiple occasions. Mr. Matthews referred Mr. Miller-Lewis to a psychologist, Dean Janover, in 2016. Mr. Miller-Lewis saw the psychologist on a weekly basis until the end of his employment with Hawthorn. In 2015, Hawthorn offered Mr. Miller-Lewis an extension to his rookie contract. Mr. Miller-Lewis accepted. Mr. Miller-Lewis moved into his own rental house. Miss Lewis and Ariana moved to Melbourne, arriving the 24th of December 2015. On or about the 12th of April 2016, Mr. Miller-Lewis's family in Western Australia informed Mr. Miller-Lewis and Miss Lewis that Mr. Miller-Lewis's grandfather was very unwell and he would be having surgery on the morning of the 18th of April 2016, urgently asking them to return to Perth. On or about the 12th of April 2016, Mr. Miller-Lewis and Miss Lewis asked Mr. Matthews for urgent help to travel to Perth to see Mr. Miller-Lewis's grandfather in hospital. Hawthorn did not substantially respond for a number of days. On the 18th of April 2016, at 1 a.m., Mr. Miller-Lewis and Miss Lewis arrived in Perth, by which time Mr. Miller-Lewis's grandfather was already in surgery. Mr. Miller-Lewis and Miss Lewis were unable to see his grandfather before he passed away. On the 20th of April 2016, Mr. Miller-Lewis and Miss Lewis were required to return to Melbourne. As a result of the prompt return flight, Mr. Miller-Lewis was unable to participate in any cultural ceremonies or practices in respect of the death of his grandfather. In August 2016, Mr. Miller-Lewis and Miss Lewis learnt that they were expecting a second child, and they did not tell Hawthorn. In or around late 2016, Hawthorn required its players to attend a pub or restaurant. Mr. Miller-Lewis was anxious about the event because of past traumatic events around involving alcohol. Miss Lewis drove him to the event, but he left early. After the event, Mr. Burt sent him a text message to the effect that he was disappointed in Mr. Miller-Lewis for not being more sociable outside of the football club and for failing to spend time with the other players. Copies of the text messages are no longer available to Mr. Miller-Lewis. Throughout Mr. Miller-Lewis's employment at Hawthorn, Mr. Clarkson nicknamed Mr. Miller-Lewis JJ, referencing a black character from the 70s TV show Times. Frequently said JJ Dynamite to Mr. Miller-Lewis, referencing that character's catchphrase Dynamite. Mr. Matthews conveyed views on Mr. Lewis's personal life to Mr. Miller-Lewis, Miss Lewis, and other family members of the Miller-Lewis's family. For example, Mr. Matthews conveyed his views as to whether Miss Lewis and Miss Miller should visit and live with Mr. Miller-Lewis. Hawthorn set an expectation that Mr. Miller-Lewis and Miss Lewis would seek permission or approval from the club on decisions they made in their personal lives. For example, Hawthorn set an expectation that Mr. Miller-Lewis and Miss Lewis would seek permission or approval before Miss Lewis visited Mr. Miller-Lewis in Melbourne. Mr. Miller-Lewis's employment at Hawthorn ceased in 2016 when he was delisted. Mr. Miller-Lewis informed of his delisting at a meeting at which Mr. Clarkson and Mr. Burt were present. Mr. Clarkson said words to the effect that Mr. Miller-Lewis had a lot going for him, both inside and outside of football. Mr. Clarkson said words to the effect, there are other people at this club that don't deserve a second chance but will get one. And then there are people like you who deserve a second chance but will not get one. Mr. Matthews and Mr. Lewis Mr. Miller-Lewis had conversations about Mr. Miller-Lewis's delisting, in which Mr. Matthews said words to the effect that while there are other players that Hawthorn worry about and hold concern for in regards of their mental well-being and transitioning out of AFL life, that Mr. Miller-Lewis would be fine. Mr. Matthews gave Mr. Miller-Lewis a pamphlet which included information about support services available in the event of delisting. The pamphlet is the AFL Players Association Transition Services Guide. Hawthorn did not, through any of its employees or otherwise, guide Mr. Miller-Lewis through the transition process, nor offer Mr. Miller-Lewis any support services. Initially refused to pay for Mr. Miller-Lewis's relocation costs and agreed to do so once he complained. Mr. Miller-Lewis and Miss Lewis returned to Perth. Despite Mr. Miller-Lewis being delisted, Hawthorn kept an artwork of his and prominently displayed it. The artwork featured the Hawthorn mascot surrounded by a detailed dog painting. Mr. Matthews asked Mr. Miller-Lewis to complete the artwork in 2016. Mr. Matthews displayed the artwork in front of his office near the club's lift entry. Hawthorn did not pay Mr. Miller-Lewis for the painting or the right to display it. Initially would not return the painting to him, despite a request to Mr. Matthews in June 2021 by him and Miss Lewis. Only returned it to him on the 13th of March 2022 after another request to Mr. Matthews on the 25th of February 2022, which was reiterated on the March 9th, 2022. The requests were made by phone call and text messages. Okay, so now we've got the conduct in respect to Mr. Leon Egan. Mr. Egan is a Yorta, Bangarang, Ridaji, and Gunjamara man. In 2012, Mr. Burt approached Mr. Egan to act as an Indigenous mentor advisor to Hawthorn's Indigenous players. He was contractually engaged by Hawthorn to provide services 1 day per week to manage and monitor the welfare of Indigenous players and support their development. Mr. Egan provided these services through his consultancy company, EEGAKAT Consulting. Thereafter, from the 1st of February 2013 to 31st of October 2013, Mr. Egan was once again contractually engaged by Hawthorn to provide services through his consulting company 1 day a week to manage and monitor the welfare of Indigenous players and support their development. In 2014, Mr. Egan was formally employed by Hawthorn for 5 hours per week, pursuant to a memorandum of understanding with AFL Sports Ready, during which time his roles were mentoring Indigenous players, career development of Indigenous players, cultural awareness, supporting Indigenous around and NAIDOC REIC, representing Indigenous players' interests. In 2015, until his resignation in October that year, Mr. Egan continued to be employed by Hawthorn pursuant to the MOU. From 2012 to 2015, Mr. Egan's duties included from time to time acting together with his wife as host family for Indigenous players employed by Hawthorn. Before accepting the engagement in 2012 and during the engagement and then employment, Mr. Burt and Mr. Egan regularly discussed the role becoming a full-time role. The role never became a full-time role. There was no equivalent mentor advisor role for non-Indigenous players. Despite Mr. Egan's duties throughout Mr. Egan's engagement and employment at Hawthorn, Mr. Egan was not included in decision-making about Indigenous players in respect with whom he was engaged and employed to advise and mentor. These included Mr. Anderson, Mr. Dale Garrett, and Mr. Miller-Lewis. In regard to Mr. Anderson, for example, Mr. Egan was not included in or even informed of decision-making as to whether Mr. Anderson's wife and child should be in Melbourne with Mr. Anderson, who's 79 to 83 above. In regard to Mr. Garlett, for example, Mr. Egan was not included in his decision-making as to his drafting or his treatment by Hawthorn after his delisting. In regard to Mr. Miller-Lewis, for example, Mr. Egan was not included in decision-making as to Miss Lewis and their child should be in Melbourne with Mr. Miller-Lewis, c. 129 to 143. Mr. Egan was told not to intervene or follow up with one Indigenous player. Mr. Lance Franklin experienced issues in personal life. When Mr. Franklin was experiencing issues in his personal life and was charged with driving offences in 2012, Mr. Burt told Mr. Egan not to intervene or follow up with Mr. Franklin. Because of his limited employment hours, Mr. Egan was not able to advise and mentor Indigenous players as actively as he considered appropriate for the role. Two of the players whom Mr. Egan was not able to advise and mentor as actively as he considered appropriate was Mr. Derek Ranganine and Mr. Amos Frank. Hawthorn did not regularly respond to or act on the opinions Mr. Egan expressed about Hawthorn's action regarding Indigenous issues. Mr. Egan's position description included running cultural awareness training with all facets of the club to learn and engage in cross-cultural sessions. Mr. Egan was only able to run one training session in 2013 for approximately 15 administrative staff. On multiple occasions from 2013 to 2015, Mr. Egan suggested to Mr. Burt that Hawthorn should hold training sessions for all players, senior management, general staff, and the board. Mr. Egan was only able to run two staff training sessions and one player training session in 2015, the player session being for non-interstate travelling players. Hawthorn regularly did not facilitate Mr. Egan's request to be better informed of Hawthorn's actions on Indigenous issues. In 2015, Mr. Egan asked Mr. Burt to see, but was not provided with progress reports sent to the Epic Good Foundation in regard to their donation over 5 years from 2015 of $1 million to Hawthorn to support Indigenous programs. Mr. Egan was not recognised for work, including his role in facilitating the Epic Good Foundation event at which the donation was officially announced in May 2015. Mr. Egan was not invited with other Hawthorn staff to celebrate any of the three premierships Hawthorn won while he was employed. Mr. Egan never met with Mr. Clarkson or Mr. Fagan. On the 23rd of May 2015, during a game between Hawthorn and Sydney Swans, Hawthorn supporters booed Adam Goods repeatedly. At the time, Mr. Goods was generally regarded as one of the greatest Indigenous players of all time. Shortly after the game, Hawthorn Indigenous players Mr. Rioli, Mr. Sean Burgoyne, and Mr. Anderson, Mr. Hill posted on social media with a message calling out racism, requested that Mr. Egan relay a request for a public statement from the Hawthorn CEO, Stuart Fox, and President Andrew Newbold about the incident to express the club's support for Indigenous players and address the booing. Mr. Egan relayed the request to Mr. Matthews and Mr. Burt. No public statement was issued by the CEO or the President. Several days after the game, Hawthorn released a video statement of Mr. Luke Hodge about the booing. Hawthorn Indigenous players Mr. Rioli, Mr. Burgoyne, Mr. Anderson, Mr. Hill, Mr. Wanganing then informed Mr. Egan they considered Hawthorn's response to the booing incident to have been inadequate and they intended to boycott the following game. On or about the 27th of May 2015, Mr. Rioli, Mr. Burgoyne, Mr. Anderson, Mr. Hill, and Mr. Miller-Lewis attended Mr. Egan's home and his invitation to discuss their views of Hawthorn's response to the booing incident and their intention to boycott the following game. Mr. Clarkson invited himself to the meeting at Mr. Egan's house. He posed on himself and derailed the meeting by bringing his guitar and singing a song about Mr. Rioli, discouraged the players from going through the boycott. The group of players and Mr. Egan was sitting around Mr. Egan's dining table discussing the potential boycott when Mr. Egan received a phone call from Mr. Clarkson asking if he could come over to Mr. Egan's house. Mr. Egan consented. 1 minute later, Mr. Clarkson knocked on the door and entered the house with his guitar. Hawthorn took no steps to support its Indigenous players in relation to the treatment of Mr. Goods and its impact on them, taking into account their wishes about how Hawthorn might respond to treatment of Mr. Goods. Early in the 2015 Grand Final week, Mr. Egan telephoned Mr. Burt and said words to the effect of asking how Mr. Egan was to get his wristband to be able to enter the team change rooms after the game. Mr. Burt said to Mr. Egan words to the effect that Mr. Egan would not be able to access the rooms, as access was only for players' families. Mr. Egan said words to the effect that he was friendly to Indigenous players. Mr. Burt did not respond. Mr. Egan's employment with Hawthorn ceased in 2015 when he resigned 2 weeks after the Grand Final. Hawthorn's subsequent conduct. On the 7th of June 2019, a public statement headed the premiere of 2 films about racism experienced by Mr. Goods. Hawthorn, among other clubs, along with the AFL, made a statement recognising that racism on and off the field continues to have traumatic and damaging impact on Indigenous players and communities, acknowledging that in Mr. Goods' case, the collective failure of the AFL and the clubs to call out racism and to stand up for players, the subject of it had the result of letting down all Indigenous players, past and present. pledging to continue to fight all forms of racism and discrimination on and off the field, committing to standing strongly with all in the football community who experience racism or discrimination, committing to listening to Indigenous players and communities to learn about the impact of racism, promising to continue to work to ensure a safe and inclusive environment where Australian rules football is played, stating that it never wanted to see the mistakes of the past repeated. The statement is available and publicly available. In or about May 2022, Hawthorn commissioned a review into cultural safety of past and present players and staff at Hawthorn. It's called the Bin Marder Review. In August 2022, Hawthorn received the findings and recommendations of the review, which included findings of negligence and human rights abuses towards Indigenous Hawthorn players committed by Hawthorn employees, including between 2010 and 2015, a recommendation that these findings be immediately reported to the AFL Integrity Unit, a recommendation that Hawthorn develop and offer a reparation and restitution package, including financial reparations and an official public apology, a recommendation that Indigenous cultural immersion training be compulsory for all Hawthorn players, staff and board members on inductions and at least twice a year. On the 21st of September 2022, Hawthorn made a public statement that acknowledged the Bin Marder review, raised disturbing historical allegations that required further investigation and did not apologise. In October 2022, the AFL appointed an independent investigation panel under Rule 3.1 of the rules to investigate and consider and report on allegations of inappropriate treatment of Hawthorn players and or families. The investigation was to address, among other matters, whether during the period between the 1st of January 2008 and the 31st of December 2016, or such further period as the investigation panel considered to be appropriate, Hawthorn engaged in any of the following conduct directed towards players, their families, and their intimate partners. A, racist behaviour, bullying, or intimidatory conduct, whether towards Hawthorn listed players and or their intimate partners, family and friends, inappropriate intrusion upon purported control, including coercive control over family, cultural and or non-football lives and well-being of Hawthorn listed players and or their intimate partners, families and friends, radicalised or gendered stereotyping directed towards First Nation players, their families and intimate partners. On or about the 27th of May 2023, Mr. Burt spoke to a journalist for the purposes of an article that was published in The Age on the 27th of May 2023. Mr. Burt told the journalist, "I've got nothing to say sorry for." The article was authored by Jake Nile and titled, "I've got nothing to say sorry for. Jason Burt responds to Hawthorn allegations." On the 31st of May 2023, Mr. Burt published a Facebook post that described the subject of the investigation panel as a case of four men, Hawthorn players, that spent time at Hawthorn who needed substantial guidance, support and care, described the Bin Marder report as a disgrace and did not apologise. The post was published on Mr. Burt's Facebook page and was public. On the 30th of May 2023, an agreement by the complainants and the AFL terminated the investigation panel, but in doing so acknowledged in a public statement the hurt, pain and anguish felt by the complainants following their time at Hawthorn. The statement is in writing and publicly available. On the same day, Hawthorn responded in a public statement in which it committed to listen and learn to ensure it creates an inclusive environment for all First Nations people and did not apologise. The statement was in writing and publicly available. Hawthorn has not publicly apologised for the conduct, the subject of the Bin Marder review, the investigative panel, or the conduct subject to the statement of claim. So now they're talking about unlawful discrimination. So Carl Peterson, personal control, Hawthorn vicarious liabilities. So they're saying that the acts pleaded were done by employees and that there was exercising control over his personal life. The personal control involved a distinction, restriction, or preference based on race, his Aboriginality. The personal control had effect of nullifying or impairing his recognition, enjoyment, or exercise on equal footing of the following human rights in the economic and cultural fields of public life: the right to just and favourable conditions of work, including safe and healthy working conditions, the right of a private life. In the premises, the personal control would be a Racial Discrimination Act if it was done by Hawthorn, and applies to Hawthorn. So there's that. And then they've got here, we're acting or purporting to act on behalf of his employer, that the non-Indigenous players were not subject to the same control. And so they're pointing out that so that he's in the premises, personal harm, again, all the things. So again, they're putting it all about that it's essentially setting out all the sections of the Racial Discrimination Act, that they didn't do it to non-Indigenous people, okay? Family control, again, that they restricted his family life. And they're just listing it all over here. Okay, and non-Indigenous, that didn't happen to non-Indigenous players. Stereotyping or domineering conduct, vicarious liability, constituted Mr. Clarkson treating Mr. Peterson in a way that involved making an assumption or manifesting a stereotype concerning Mr. Peterson on the basis of his Aboriginality. You know, that no comment would have been made about a non-Indigenous person living in the shack in the desert. So again, we've got that. Okay, so it constituted Mr. Clarkson treating Mr. Peterson and his family in a domineering, inappropriate way. Again, pointing that out. So then we get into Rioli again, control over his personal conduct. So again, it's the same harmful conduct. Okay, family control and interfering with his family life. Culturally harmful conduct. Okay. It's just let's say the stereotyping. So they're talking about and his family in a way that can still make an assumption of the Aboriginality. Yeah. So have we got a specific circumstance? Okay. So again, for her, requiring it to comply with the family control requirement. The stereotyping, Jermaine Miller Lewis. So we're going to have personal control conduct. Yep. Okay. Personal harmful conduct. Family control and interference conduct. Okay. Montana Ray Lewis, Leon Egan, marginalising. So Miss Montana Ray Lewis, for the avoidance of doubt for purposes of relief, Miss Lewis was adversely affected by the matters pleaded in Part C5. C6, Leon Egan, marginalising conduct. Marginalising despite the duties of his role in his employment with Hawthorn from the relevant persons. culturally harmful conduct. And we've got direct liability. So at all times, Hawthorn knew or ought to have known it was foreseeable there exists in and transmitted throughout people, society generic ideas and stereotypes about Aboriginal people. These ideas and stereotypes are learned and transmitted by individuals living and working in Australian society. These ideas and stereotypes can result in such individuals who come in contact with Aboriginal people engaging in speech and other conduct that involves restriction, reference based on race. These ideas and stereotypes would result in individuals working for Hawthorn who come in contact with Aboriginal players and their families engaging in speech or other conduct that involves a distinction, restriction, or preference based on race. Speech or other conduct of the kind pleaded in subparagraph D could harm or adversely affect Aboriginal players, including in respect of their right to just and favourable conditions of work, including safe and healthy working conditions, the right to private life, including personal integrity, privacy, autonomy, reputation, family. Hawthorn failed to protect Messer Pedersen, Rioli, and Miller Lewis against the harm and adverse effects of racially discriminatory speech and other conduct, including speech or other conduct of the kind pleaded in 289D. Failed to take steps to prevent and or adequately respond to harm and adverse effects of such speech and other conduct. Inadequate systems conduct, particularly racially discriminatory speech and other conduct, includes personal control conduct, personally harmful conduct, family control and interference conduct, family control requirements, stereotyping conduct, domineering conduct, marginalising conduct, culturally ignorant conduct. The inadequate systems includes, without limitation, failing to provide any alternate adequate education, training or experience, anti-racism training to employees or agents of Hawthorn, failing to respond adequately or at all to instances of racially discriminatory speech or other conduct, failing to provide culturally safe working environment. The inadequate systems conduct involved a distinction, restriction or preference based on race, Aboriginality. Alternatively to 291, the effect of the inadequate systems conduct was required Messrs. Peterson's, Rioli, and Miller Lewis, or each of them to comply with condition or requirement, racist cultural condition, being that they or he work in an environment in which he was subject to conduct that was racially discriminatory and therefore harmful to Aboriginal players and their families, did not have access to measures that would have protected him against, prevented, and or adequately responded to such conduct. The racist culture condition was not reasonable having regard to the circumstances of the case. Mr. Peterson, Mr. Rioli, Mr. Miller Lewis could not comply with the racist cultural condition. The requirement to comply with the racist cultural condition had the effect of nullifying or impairing the recognition, enjoyment, or exercise on an equal footing by Aboriginal persons of the following human rights in the economic or cultural fields of public life. The right to just and favourable conditions of work, including safe and healthy working conditions, the right to private life, including personal integrity, privacy, autonomy, reputation, family. The inadequate systems conduct, alternately, the requirement to comply with the racist cultural condition had the effect of nullifying or impairing their recognition, enjoyment, or exercise on an equal footing by Mr. Peterson, Mr. Rioli, Mr. Miller Lewis of the following human rights in the economic, and it's again the same thing. So in the premises, the inadequate systems conduct was unlawful conduct within the meaning of Section 9(1) of the RD Act. Failing further or alternative non-Indigenous Hawthorn players otherwise in the same or similar circumstances to Mr. Peterson would not have been subject to the same or similar to, and then we've got all of that. Pleaded in C1, Mr. Rioli again pleaded, and Mr. Miller Lewis would not have been subjected to the conduct of that. Pleading C4. In the premises, Hawthorn failed to afford each of them the same conditions of work as were made available for other persons of having the same qualifications employed in the same circumstances on work of the same description. So we've got that. Now we get to negligence. At all relevant times, by reasons of the matters pleaded in A2 above. Hawthorn was directly or vicariously liable in tort for the conduct and actions of employees and agents. So they've named everybody there. Performed while in the courses of their agents. So at all relevant times, as employer of players, Hawthorn owed Mr. Peterson's, Rioli and Lewis a non-delegable duty of care to take reasonable care to avoid exposing them to unnecessary risk of injury, to take reasonable steps to avoid creating or exposing them to a reasonable foreseeable risk of psychiatric injury, to protect the mental integrity of Peterson, Rioli, Miller Lewis from the unreasonable infliction of serious harm. At all relevant times, it was reasonably foreseeable to an employer in the position of Hawthorn that engaging in conduct that threatened, vilified, or disparaged players on the basis of race, including conduct in breach of the RD Act, subjecting or exposing players to or failing to protect players from discriminatory conduct, including exposure to racialized stereotyping and culturally harmful conduct, subjecting or exposing players to or failing to protect players from harm or adverse effects from speech or conduct of the kind pleaded in 289D, engaging in bullying or intimidatory conduct, including of a racist and or discriminatory nature, denying the existence and impact on Indigenous players of current and historical racism, might cause distress, psychological harm, and injury to Indigenous players of Hawthorns, including Mrs. Peterson, Rioli, and Miller Lewis. Further, at all times, it was reasonable foreseeable to an employer in the position of Hawthorn that unreasonable intrusion into, disruption of, directions regarding, and exercise of purported control over the family, cultural, and non-football lives of the Indigenous players of Hawthorn, including Mrs. Peterson, Rioli, and Miller Lewis, might cause distress or psychological harm. The scope of the duty of care owed by Hawthorn to Mrs. Peterson, Rioli, and Miller Lewis included to take reasonable steps to provide a safe place of work for the players, to participate in the AFL competition as professional football players, including in matches, training, and preparation, not engage in, prohibit, prevent, and cease discriminatory and cultural harmful conduct by employees and agents at Hawthorn, directed at Mrs. Peterson, Rioli, and Miller Lewis, not engage in, prohibit, prevent, cease discriminatory and cultural harmful conduct by employees and agents at Hawthorn, whether or not personally directed at Mrs. Peterson, Rioli, and Miller Lewis, to which Mrs. Peterson, Rioli, and Miller Lewis were exposed to or aware of, take reasonable measures in response to the foreseeable risk of harm or adverse effects from speech or conduct of the kind pleaded in 289D, including sufficient anti-racism training as defined in 290 above to mitigate that risk. Ensure that from time to time Hawthorn provided and ensured participation in cultural awareness and anti-discrimination training for all of its employees and agents. Comply with, enforce, and prevent contravention of relevant rules, policies, and codes as enforced from time to time, including the Peak Rule, the Players' Code of Conduct, in particular the non-vilification provision, from around 2006 to 2013, the ADH policy, from 2013, discrimination policy, from 2017, the R&R policy, and the vilification framework. Avoid unreasonable intrusion and exercise control and influence over the family, cultural, and non-football lives of Mrs. Peterson, Rioli, and Miller Lewis, including by the way of direction by or purportedly on behalf of Hawthorn by its servants and agents to their players of their partners or their partners. Avoid taking steps that reasonably created or gave rise to an unreasonable risk of disruption in the family and cultural lives. We're taking active steps to become involved in the personal lives and decisions of Peterson, Rioli, and Miller Lewis, or purportedly on behalf of Hawthorn, considering the welfare of them and ensuring the welfare of them were not adversely affected by the intervention. Ensure adequate Indigenous advocacy, voice, or representation at Hawthorn to support Indigenous players, including by adequately funding, supporting, and heeding Indigenous liaison officers at all times. Recognise and acknowledge the fact that historical racism at Hawthorn and the AFL take steps to reduce the ongoing impacts of that historical racism. The reasonable standard of care by reasons of the conduct set out in B3, Hawthorn, including by its ways with servants and agents, was negligent and breached the duty of care owed to Mr. Peterson. So, and again, we've got the particulars of negligence here. And so now, again, the negligence and breach of duty of care from Mr. Rioli, failing to respond to complaints by Mr. Rioli and Miss Sam Rioli, Mr. Miller-Lewis. Here, as a consequence of the unlawful discrimination and or negligence, Mr. Peterson suffered loss and damage. So then we've got distress, pain and suffering, psychological harm, personal harm, cultural harm, loss of earnings, and will be provided on a filing of expert evidence. Got the same thing for Mr. Rioli, Miss R. Sam Rioli here, Mr. Miller-Lewis, Miss Lewis, and Mr. Egan. Okay. Then we've got aggravated and exemplary damages. In respect of negligence claims was in knowing, deliberate, callous, flagrant, and contemporaneous disregard for the rights, and is liable to pay to the applicant's aggravated damages. So that is the pleadings. Okay, so that's the certificate of the lawyer there, and that was a big read, and I apologise. I did stumble over that because that was a big read. So we get back to that is the claim. There's a lot in there, and I don't know what you think about it. It is there, as I said, there is a lot in there. So we can see here that on the 22nd, so on the 2nd, there was directions, and then on the 22nd of August, there was a chambers. This is not for publication. It wasn't not for publication. It was an adjourned pre-hearing. So there was an order made. So let's have a look. And it was a consent order. So it was by order of consent, which means that they've agreed to it. So they've set aside here. So the case management hearing on the at 9:30 on the 23rd of August be vacated. So this was the day before. That by 4 p.m. the 20th of September, the respondent file and serve its defence. So we're going to have a defence. Then on 25th of October, the applicants file and serve their reply. Now, the proceeding to be referred to mediation to be conducted by Kate Eastman SC. Such mediation to occur no later than November 22nd, 2024. Everything generally gets referred for mediation because ideally you want it all mediated and sorted out before going to court. So subject to proceeding not resolving, it's been listed for a case management hearing on the 3rd of December 2024, costs to be reserved and liberty to apply. So that means that the costs to be reserved, they'll be decided at a later date, and that some down that they can apply for costs down the track. So that is where we are at the moment. As I said, there's a lot in there. I think I'd be very interested to hear or to see how young non-Indigenous players were treated and dealt with, and I guess that's the benchmark. That's the benchmark. But I don't know. There's a lot in there. There's a lot that I can say, but I really just want to give you the facts. This is what's been pleaded. This is what they've said. It's a big document. It's available on the Federal Court of Australia website under public interest cases. But yeah, look, I'm interested to hear what you've got to think, what you think. What are your thoughts on the matter? There's a lot to get in there. There's lots of allegations in there, and I don't know where to start or how to get there. on one hand, I can see if you're 18 and you're expecting a child, how that, if you took race out of it, if you're 18 and expecting a child, there's going to be people that say stuff to you. As for the comment about can't afford jeans, that you're wearing ripped jeans, I must say I've said that to my daughter a few times. How much did that cost you? I could have given you a pair with rips in them. So I don't know whether they were comments where some of the comments were made, but they, innocently, and they've been taken the wrong way. I just don't know. I just don't know. I'm really conflicted about this because I can see from both points of view. I can see how they feel this way, but I can also see, on the other hand, that you've just been drafted, you've got your first big game, and then you find out you're expecting a child. I don't know. I mean, I do know some player agents now. Now there are players, particularly young players, but they've got managers. The money's put into a trust fund for them, and that they're given an allowance, and that if they need more money, they can get it. But they're really trying to teach them to budget, and that's so I can see that happens to a lot of the younger players now. So, and I don't know whether they've, as I said, I just don't know. So anyway, I'd be interested to see what you think. Please leave a comment below. That was a marathon. I apologise. I've tried to read it all succinctly, but that's where we are. There's a lot of allegations in there. So this is on its third. I don't know. Anyway, let me know what you think. Anyway, I'll catch you next time. Bye for now.